Hello, welcome to today's video, and in this series I'm going to be talking about what to do or what do you do when a shareholder of your company is deceased. Now, before I get to the points, let me lay a few ground rules. First of all, a limited liability company is a corporate structure that is regarded with a status of a legal entity. What that means is that it is a person of its own, and so the fact that a member of the company, either a shareholder or director of the company, dies does not mean that the company comes to an end, right? And then secondly, every company must have members, and in this case it is either a shareholder or a director. Now, directors of a company are high-level employees of the company that are charged with managerial responsibilities. In other words, they are charged with the responsibilities of overseeing the day-to-day operations of a company. And then you have shareholders. Shareholders are part owners of the company to the extent of their financial contributions towards the capital of the company. In simple terms, let's say XYZ company was formed, and at the time of it being formed, it was formed with 1 million naira as its capital. Now, at the time of the formation, Mr. A contributed 300,000 naira to the 1 million authorized capital of the company. What that means is that Mr. A is a shareholder of the company to the extent of the 300,000 naira contribution that he made at the time the company was being formed. Now, the question is, what happens in a situation where Mr. A, in this scenario, that who is a shareholder, is deceased? Now, there are three things that every company must do when these kind of things happen, and I'm going to be sharing them shortly. The first thing to be done is that the company must ensure that they go back to their operating documents that governs situations such as this. In Nigeria, every company has a governing law that guides their operations, and it's referred to as the Articles of Association of the company. Now, the Articles of Association of a company, or a properly drafted Articles of Association of a company, must always make provisions for transmission of shares. In other words, you definitely make provision for what will happen in a situation where a shareholder or even a director is no more, right? Now, the law gives options or affords various options in such scenarios. It is either of two things. It is either the shares of that deceased shareholder will be transferred to the next of kin or the surviving next of kin or beneficiary, which is referred to as a transmittee of the shares, right? Or in the second option, this beneficiary can decide not to own the shares, but instead opt to transfer it by way of either a sale or a gift to an existing shareholder in that same company. Now, depending on whatever scenario happens there, right, the company has to be aware of it and oversee that transaction, right? So in the situation where the beneficiary of these shares, that is the surviving next of kin of transmittee, says, okay, I want to inherit the shares and I want to remain a shareholder of this company, the company is going to be aware of it and do what is necessary to admit this transmittee or beneficiary as an official shareholder of the company. What this means, of course, is that this new beneficiary is going to be afforded rights and privileges as a new shareholder of the company. Now, in a situation where this beneficiary says, no, I want to sell my shares or gift it out to an existing shareholder, the company is also supposed to oversee that transaction and ensure that a proper transaction or transfer instrument or agreement is prepared, recognizing the transaction that enables the transfer of the shares that the beneficiary has to the shareholder who is interested in acquiring those shares, right? Now, I'll chip in here. It is important that you consult your company secretary if you have one, or your company lawyer if you have one. They will be in a better position to interpret what the company's Articles of Association is saying and also render professional advice on the next steps to take based on what is contained in the company's operating or governing document. Now, the third step to take is that the company must update its records and also inform the corporate registry in Nigeria, which in this case is the Corporate Affairs Commission. It's not enough to oversee the transfer of shares or appointment of new shareholders. It is important that the company always updates their records and don't just update it internally, but also notify the governing agency that is responsible for overseeing the operations and activities of companies in Nigeria, which is the Corporate Affairs Commission. Now, if a company updates its records internally, or where a company updates its records internally but fails to do the appropriate filing with the Corporate Affairs Commission, that activity or the transfer of shares or whatever transaction happened in such situation is as good as invalid on having not happened, because the fact that there was an agreement and it's not recognized, or the records were not updated at the Nigeria Corporate Registry. As far as the registry is concerned, no such transaction has taken place. And that could go a long way in affecting a lot of things you might want to do in future. So it's important that any change that happens in your company, whether it's a change of a shareholder or whatever happens, right? It's important that you not just update your records internally, but ensure that the corporate registry is also aware of whatever internal change is going on. This will help them to also update their own records to reflect what is going on with your records, and it will also help with the company's future or subsequent transactions. So in summary, I've said three things. Whenever the shareholder of your company is deceased, first, consult your company secretary or your company lawyer to study the articles or the operating law governing the operations of that company to advise you on the next step to take. Now, depending on what is provided in that governing law, it's either of two things. It's either the governing law allows for the transfer of shares to the next of kin and also makes provisions for the option of the next of kin to either transfer the shares to an existing shareholder. Whichever is the case, ensure that the company is aware of it and oversees that transaction. In the event that there is a transfer, there must be an operating instrument that governs or enables the transfer of shares between the beneficiary and the interested shareholder to be valid and to take place, right? And thirdly, update the company's records, not just internally, but with the Nigerian Corporate Registry, which in this case is the Corporate Affairs Commission. So there you have it. Three things to do, very important things to do whenever the shareholder of your company is no more. I hope you got value from this video. If you have any questions, feel free to leave them in the comment section. And if you need to speak with a legal team or one of our legal team, feel free to reach out to us through any of the contact information that is displayed on the screen, and we will be delighted to attend to you. Until I come your way again, bye for now.